SJC-12884, Rahim v. Rachel Rollins in her official capacity as District Attorney.
And I'll also tell counsel that Justice Cipher is recused from this matter. So we'll start with Ms. Cook.
May it please the court, Kate Cook on behalf of Rahim. This case turns on two questions. First, does Massachusetts law require the district attorney to produce records it received from a federal agency? And if so, does federal law compel a different result? On the first question, there can be no doubt that documents that the district attorney received, relied upon, and has retained for several years are public records under Massachusetts law. The definition of a public record under Massachusetts law is any document made or received by a state agency. Ownership has no bearing on a state actor's obligations under the law, and there's certainly no exemption for a loan. The district attorney did not extinguish its public records law obligations by entering what it described in its findings report as a non-disclosure agreement with the FBI. The court made this clear in Champa v. Weston Public Schools, holding that a confidentiality agreement cannot trump the public records law. The district attorney in the United States have failed to meet their significant burdens to show that any exemption applies or why none of the records can be produced with redactions. As to statutory exemption A, there simply is no provision in FOIA expressly or as a practical matter that prohibits disclosure of documents in the possession of state agencies. FOIA by its own terms does not even apply to state agencies. And for a recent example of a state rejecting this very argument, see Harper versus Missouri State Highway Patrol cited in our reply brief. On the second question, nothing in federal law.
I have a question for you.
Yes.
Can you address the investigatory exception? Because I think the strongest argument perhaps from the government is that if these records are turned over, the next time we have a shooting that involves out-of-state or federal joint investigations, they're not going to give it to us. So that involves an investigatory technique which is going to harm public safety. So could you address that, please?
Absolutely, Your Honor. There are several reasons why this court can enforce the Massachusetts public records law and it will not jeopardize public safety or future federal state investigations. First and foremost, let's talk about what these documents are and what they're not. These documents were not provided to the district attorney's office during the course of the JTTF investigation. They were provided to the district attorney at its request after law enforcement officers, an FBI officer and a Boston police officer, shot and killed Ms. Rahim's son. Secondly, I anticipate my brother and my sister will tell you one of the major reasons why this might harm future federal state cooperation is because releasing these documents to Ms. Rahim will reveal the names of the officers involved in the shooting. However, that overlooks the fact that over 2 years ago, Ms. Rahim agreed to accept the records with any personally identifying information redacted. A third and major reason why I think the court can take comfort that it can enforce this law without jeopardizing future investigations is that our Massachusetts public records law has several and significant exemptions that the legislature has carefully balanced the need of the public to receive documents against various public policy interests, including, as Your Honor notes, the investigatory exemption. And we do not dispute that there very well could be information in these records that is subject to the investigatory exemption. What we do dispute is that at this time, the district attorney has actually met its significant burden to prove with specificity that any of the information actually meets that.
I read the so-called Vaughan Index, and I take your points on specificity in that. But you still respectfully haven't answered my question about investigatory techniques, and your client rightfully had a FOIA request that was denied, and then we get this litigation under the public records law. And I also very well take your arguments that they're two separate analyses on the preemption argument, which I guess we'll get to. But the question I specifically asked you is, under the investigatory exception, the government argues that if someone is able to essentially get federal, what used to be federal records, assuming that you're correct on possession, in this way, the next time there's a shooting, or the next time the BPD asks for federal documents and the feds give it to them under these caveats, they're not going to do it because it's going to be disclosable under the state public records law. How do you address that part of the investigatory exception?
So I think the United States itself has conceded, Your Honor, that there are alternative ways that they could provide information, cooperate with an investigation when an FBI officer kills a Massachusetts citizen without actually depositing those documents where it triggers our Massachusetts state public records law. They could also perform a live interview. There are other ways to do this. And I would also note,
so they're going to have to say, come down to the Moakley, go into a conference room and read, and then leave.
Yes, Your Honor. They could do that. Or they could know that we have a very rigorous and robust public records law that protects investigatory techniques under our state Massachusetts public records law, exemption F. And if the court enforces a public records law in this case and it's remanded, there will be significant discussions and protections provided by that exemption to ensure that investigatory techniques and the other things that our state legislature have decided should be protected would be withheld.
And I'll turn to Justice Lowy in a second. I just have one last follow-up question on that, Ms. Cook. And I probably should be, I should probably know this, but you'll tell me. The remedy you're seeking is a remand to really look at the sufficiency of the investigatory exception as applied in this case, correct?
We're realistic that we don't think the lower court actually did a deep dive into what exemptions apply and how. Obviously, in our complaint and in our briefing, we have sought the release of the public records to Ms. Rahim, but of course that's always subject to the exemptions that apply. And there's other exemptions, Your Honor, that I think the United States and the district attorney could take comfort in based on their contention that releasing this document jeopardizes future investigations and cooperation, including the public safety investigation,
right.
Of course, the privacy investigation. And as I said, we have already agreed that
the privacy exemption.
Pardon me?
The privacy exemption, right?
Yes, Your Honor.
Okay, thank you. Justice Lowy?
Yes, Ms. Cook, what about if there really is a conflict with the federal statute and that the federal courts would interpret the reasonably interfere with law enforcement more broadly than we might with our public records law? If there's a conflict, wouldn't the federal disclosure regime prevail?
I don't think so, Your Honor. First of all, we are operating in Massachusetts on our state public records law under Massachusetts public records law. The FOIA law and its exemptions do not apply to state agencies. And courts around the country have reviewed the question of whether to incorporate FOIA exemptions when a custodian objects because they don't want to release federal documents that they've received to conduct state or local government business. And courts have routinely said that's clearly not what Congress meant when they drafted FOIA. I think one of the first lines in the statute is referring to an agency, and it's referring to federal agencies. So the fact that if a request is made to the FBI and they might interpret their federal statute, which applies to federal agencies and does not apply to the Suffolk District Attorney's Office differently, I don't think creates the kind of conflict that's contemplated by the Supremacy Clause. As this court has said, the Supremacy Clause is not a source of federal rights. It merely accords priority when there is a conflict, and there's not a statutory conflict between the federal law and our state law. There might be a difference of view or desire from what the FBI would like and what actually is said in the FOIA versus our state public records law, but that's not the kind of conflict that triggers the supremacy clause.
Justice Kapka.
I'm following up on Justice Lowy's question because I'm not sure I understand. So we have, these were originally federal documents. They're federal documents, right? There's a federal FOIA request. It's denied. So the federal government has decided under FOIA, this stuff shouldn't be released, right? And now they've loaned the documents or even, passed on the documents to the state. Isn't there a conflict between the state's public records law and the federal law when the application, FOIA says don't release these documents. These are federal documents and now they're going to be released under the state public records law. Isn't that a direct conflict? I'm confused. The statutes, if the application of the statute leads to different results for federal documents, isn't that a conflict governed by the supremacy clause?
No, it's not, Your Honor. First, I just wanted to clarify the request that was made to the district attorney happened simultaneously with the request to the federal government. So it's not as though Ms. Rahim waited for a rejection and then tried to do a back run, as I think my brother suggests. I just want to correct that.
I don't think that matters, but it's just the feds have concluded. I agree with you. I don't think there's anything suspicious about what you did. I'm just seeing the result. I just can't see how we can have different results on federal documents without having a supremacy clause problem.
So it actually happens all the time. And first, the FOIA does not expressly say that these particular documents shall not be released. That is an interpretation by the FBI of what the exemption means and how it applies. And the FBI, I would submit, when they entered their non-disclosure agreement with the district attorney's office, was well aware that states have their own public records laws and that these documents very well might be subject to the state public records laws, because we're not the first state where this issue has arisen. And I would suggest, Your Honor, if you look at the Harper case, this exact argument was made. Isn't there a conflict that triggers a supremacy clause between FOIA and the Missouri Sunshine Law? And the court said, no. If you look at that language, if you do a textual read of FOIA, there's no way that Congress intended it to extend to states, period, much less how states incorporate their public and interpret their public records law.
Ms. Cook, is this a labeling issue in that one of the premises is that these are federal documents, and your position is once they were given to the state and came in possession of the state, they are no longer federal documents? They're documents that are possessed by the state and subject to our public record.
So Your Honor, we don't dispute that these may well be federal property, as my brother claims. What we are asking this court to affirm is the fact that our state legislature has chosen to define public records as anything made or received. And I would submit we get our state agencies and local governments receive federal documents all the time on every possible important issue of public policy. So if the court today finds that somehow, just because they came from the federal government, even though the legislature has not created any kind of ownership or property requirement for deciding when agency has to respond to a public records request. But if suddenly all documents that our agencies receive from federal governments are no longer subject to the public records law, we will effectively have gutted the law in large part on a lot of very important areas that I don't think our state legislature intended. And again, and this goes back to Justice Kaffer's question, I don't think you can read FOIA and reasonably see that statute creates a conflict with our state public records law. It doesn't apply.
In your position, it makes no difference what preconditions are established by the feds to get the documents.
And you're referring to the cover letter?
Right.
Your Honor, I don't think that our state agencies, just like the school district in Champa, can enter side agreements we're going to call this a loan, so it won't be subject to the public records law. If every records custodian in the Commonwealth can do that, then our entire public records law system has essentially gone down the gutter, or could.
Other questions for Ms. Cook? Let's go to Justice Link and then Justice Kafka. We have to unmute. There you go.
Not that I thought I was going to get through a session without having done that, but anyway, I wanted to know whether you could help me figure out whether or not Harper from Missouri is the only case that supports your position.
No, Your Honor, there are other cases, and they're cited in both our opening brief. One is out of the state of Washington, Progressive Animal Welfare Society versus University of Washington. That's a case where the university had received federal documents from the National Institute of Health, which the federal government very much claimed was subject to an exemption and did not want the documents to be released. And the state of Washington held, under our state public records law, notwithstanding claims of preemption, notwithstanding a supremacy clause argument, that as I've already stated, because FOIA only applies to federal agencies and not state actors, there is no conflict. Both the federal statute and the federal FOIA statute and the Washington Public Records Law are in harmony, and those documents had to be produced, of course, subject to their own exemptions. Similarly, Missouri actually had a prior case, I believe it's Allen versus Department of Elementary and Secondary Education, where they similarly found, again, there was a claim that FOIA should apply, should preempt, and the court said no under our state records law, which Missouri has a very similar public records law to Massachusetts. Instead of saying any document made or received, it's any document retained, and which has a similar touchstone of possession, and reach the same conclusion. Those documents had to be released under state public records law. And there's some others cited in our reply brief.
Could you tell me roughly how many states are involved? How many states do you have?
I believe we have 4.
All right. You have any go the other way?
Not that I'm aware of, Your Honor.
Okay.
My brother and sister will tell you this is just like Napper, and you should do exactly what the District Court and the 11th Circuit Court of Appeals did in United States v. Napper. But I will tell you this is not like Napper, because the United States v. Napper case was not a public records case. Ms. Rahim is here before the state's highest court asking you to enforce our state public records law. In Napper, that did occur, but not in the case that my brother and sister rely on. It happened in an earlier case before the Georgia Supreme Court, where that court found under the Georgia public records law, indeed, these records should be released. What United States v. Napper is a very different case and a different question. And it involves the fact that the United States had shared documents with the city of Atlanta pursuant to a federal statute, which has not been cited, is not claimed, is not relied upon in this case. That statute said, if these records are disseminated, we get to cancel the agreement and get our records back. And that's what the United States in their complaint in the district court sought to claw back and receive their documents. And the court agreed. And the 11th Circuit affirmed that. But that's a very different issue. That issue hasn't arisen in this case.
Could it? Could it?
In this case before the SJC?
Yeah. Could it? Because there's no such statute that's being claimed. There's no such statute that's applicable, or what?
So I think there's several reasons why it couldn't and it hasn't happened here.
Okay.
First of all, in Napper, the United States sought to intervene. In Napper, there was the federal statute at play, which clearly did have a conflict with the state public records law. The federal court was left with a decision of, are we going to enforce what Congress has decided should be the rights of the federal government to retrieve its property? And it decided in the affirmative. I submit, Your Honor, those facts just aren't here. So it's not that maybe under some factual situation that could occur, but that hasn't happened here. There's no clawback statute at play. It hasn't been cited. And the United States hasn't asked for their property back either.
Justice Kafka?
The Washington case you mentioned, was there a prior determination that FOIA would not have allowed the disclosure of the federal document in the Washington case?
Was there a prior decision, meaning from the lower court?
Or even, did the federal agency refuse to turn it over under FOIA? And then the state overruled that decision?
I don't think so, Your Honor.
Okay, and in Napper, so you say the Georgia Supreme Court says public records require its disclosure, and then the Fed said nothing doing in Napper. So isn't that right on point? I'm confused why that's not exactly the situation we're inviting if we rule the way you want us to.
So this, I submit that this court has the obligation to rule on what our public records law requires, both, and it'll be beneficial to custodians and to requesters. Are we going to allow our state agencies to enter agreements that they call a loan? Or are we going to say any documents you receive from the federal government aren't covered by the public records law? That's certainly not what our state legislature has said. And so, you know, I don't think the court should make that very important decision of public policy based on the specter of what the federal government may or may not do at some time. And this case has been percolating, obviously, for 3 years. The United States has sent a AUSA to every hearing. They've had opportunities to be involved.
Well, they're saying you can't turn it over. I mean, I read the brief. They disagree with you. They're pointing out where there's a direct conflict, you can't, it's going to violate the supremacy clause.
They do say that, Your Honor, but they have yet to point to an actual law that directly conflicts with state law. FOIA, there's no way to read FOIA and think that it creates any obligation for a state actor. It is strictly about when a federal records custodian receives a public records request, what they provide. That's what FOIA is. It does not in any way speak to whether the states, when they're in possession of documents which the federal government voluntarily hands over to a state agency, how they should be interpreted. It just doesn't speak to it.
Any further questions for Ms. Cook? Thank you. We'll hear from Ms. Padalano.
Good morning. If it may please the court, Your Honors, Donna Padalano on behalf of the Commonwealth. I know that there is, based on the questions of my sister, that there is this draw to go to the investigatory exemption, but I think it's important for this case for the court to fully define made or received under the Massachusetts public records law, whether these federal FBI property implicating national security and loan to the district attorney were in fact made or received, and the answer must be no, and the statutory interpretation needs to be addressed.
Well, Ms. Padalano, the plain language really is against you. I mean,
Your Honor,
made means, created, received means come into possession of. You didn't create them, but you certainly came in possession of these documents. The legislator could have said owned, they didn't. And the way I look at your interpretation of made or received, it seems to be owned.
Your Honor, I think that it's important to read the words together to understand the property rights that are implicated by made or received. And because it's not defined in the statute, you need to understand the plain and ordinary meaning of the words. And here, it's really the analogy is to an easement. We receive these property. We receive the federal property, and the motion judge below did define them as federal property, and we received them not with the full property rights. We had no right to disseminate the information to anybody without the permission of the FBI.
The overall gloss is for disclosure, right?
Of the public records law.
Of public records. So when we're looking at the statutory interpretation, we have to keep in mind that disclosure is favored, correct?
Yes.
So when we get into this easement property rights, to me, it seems like a bit of a stretch because made or received has particular plain language connotations.
Well, first, I do want to clarify for the record that, but for a stipulation that we entered into in 2017, this property would be in the hands of the FBI. And I think that really supports our argument that it was only for a loan that the district attorney received them. And public policy really supports this. It would be contrary to the public interest, as you brought up in your questions, that a reading to release this when we're not the owners of this property, where we may not understand the importance of the individuals who are named, the investigations that are revealed, the investigatory techniques that are revealed in the cases that might be implicated here. That's known to the FBI
Right,
best.
that gets to the exception. What about the point that you can't contract away your public records obligation that's been raised by counsel,
Right.
by having the caveats and calling this a loan as opposed to possession?
Well, I think that, when you talk about made or received, that has to go back, the contract, to the property rights that we had when we received them, and that we could not compel the federal government to provide us anything, and to not recognize the reservation of rights that the FBI had when they provided these documents and materials to the district attorney would essentially chill whatever happens in the future. And you're right, these two things, the property rights and the investigatory exception, really have to be read together. I think, these were not materials that were deposited to us. And I think that's one of the reasons why the summary judgment judge, when he was considering it, went to the Burka analysis and really looked at the four factors.
But they were deposited to you. Someone took a banker's box of documents and gave them to you.
Well, loan them to us, yes, and they are supposed to be back in the property of the FBI.
Right,
now.
and right now they're at the BPD or in your office, correct?
They're in my office, Your Honor, yes, under the 2017 stipulation. Otherwise, believe me, they would be back in the hands of the FBI.
So when you trip over them in the morning, wouldn't you say you've received them?
Your Honor, I would prefer not to trip over them in the morning, and so then I would, move to the if the made or received and the property rights are not compelling to this court, then I would certainly cite, for public safety purposes, the public safety, the privacy, and the investigatory exemption.
Right, on that, can you tell me? I looked at the Vaughn Index, and there's a lot of sameness in that. And,
yes,
and I commend your office for the diligence in putting that together and how thorough it is. It certainly identifies the individual documents, but it has the sameness of description.
Sure.
How does that particularize, since it's your burden on an exemption, what needs to be litigated in order to satisfy that exemption?
Well, first, I do want to point out that that Ms. Rahim did receive over 1,000 separate records, individual records from our office. And then the Vaughn Index, again, it's challenging in order to give specificity because of the investigatory exemption and what might be revealed as to matters of national security when there are terrorism investigations, and that those investigations are ongoing.
Are you relying on that specter, or are you also relying on the fact that next time there's an investigation involving the BPD and the FBI, you're not getting the documents?
I think you can't separate those two items. They have to be seen together. That there could certainly be a chilling effect if these matters are provided. And I do have to go back to the property interest again, because this material, because it is federal property, because it is the property of the FBI, they are really in the best position to determine what is of a sensitive nature, what continues to be of an investigatory nature and should be exempt. And one of the reasons why the motion judge again relied on as a secondary reason why these documents should not be released for the investigatory exemption.
Justice Kafka.
Yeah, I'm trying to understand whether I'm misunderstanding the conflict the supremacy clause issue, because it's a much easier way for you to win, if I'm right, than what you're trying to do, which you're swimming upstream pretty hard. So am I wrong on that, that if the feds declared this federal document not releasable under FOIA, and then we have the exact same document being released under state law, why isn't that a supremacy clause problem?
Your Honor, I didn't have a moment to say at the beginning of the argument that given the United States' compelling interest in that conflict, that I'm going to leave it to Joshua Handel of the United States to address those matters in the government's amicus brief.
I'll wait for Mr. Handel.
Thank you.
Just slowly.
But with our public records law, nonetheless, one of the reasons that a public record doesn't have to be produced is because statutorily it's prohibited from being produced. And I think your position is that the federal statute, 5 USC, whatever it is, precludes producing these documents. And that's a statutory reason under the Mass Public Records Law. So do we have any case, public records law case, where the statutory reason for not producing was a statute that wasn't a Massachusetts statute?
Not that I'm aware of, Your Honor, but I'd also like to take a moment just to point out how the cases that my sister cited do not necessarily support her position. In particular, in the Allen case out of Missouri, there's a difference because they talk about documents being retained, and that's not what happened here. The documents should be back in the hands of the FBI. We had no interest in retaining those documents, and that is completely different than made or received, I would argue here. The other thing about the Washington case, the state law there is different. And in Harper, it's the shooting of a state trooper and not in a federal investigation that implicates matters of national security into a terrorism investigation. So I think for those reasons, both on the law and on the facts, those cases are not supportive of what the Commonwealth is asking for here. I mean, sorry, not supportive of what the plaintiff is asking for here. My apologies.
Mr. Slake.
What would you say is your most persuasive case?
I do, Your Honor, think that Napier, although it, as my sister pointed out, has a different procedural background, it really talks to the fact that the federal property should be controlled by FOIA and not by a state public records law. That and I, can say that the DA should not be put in the position here to decide what records to release when they are the property of the FBI. If there are no further questions, I give my time to my brother.
Mr. Handel.
Good morning, Your Honors, and may it please the court, Josh Handel for the United States. At the outset, I want to make clear that we agree with the district attorney that probably the most straightforward way to resolve this case is to read the exemptions in the PRL to encompass federal investigatory records that the FBI has already determined are exempted from disclosure under FOIA Exemption 7. We think that that reading will avoid an unnecessary conflict between sovereigns. It will preserve the benefits of federal state law enforcement going forward. It appropriately allocates the risk assessment to the FBI rather than to the district attorney, who has no reason to be aware of other pending federal investigations. And it respects the considered judgment of the FBI as to which of its own records would, if disclosed, be harmful to federal enforcement actions.
Mr. Handel, how does that work where we have an exemption, there's a FOIA exemption that was applied in this case for investigatory means, and then we have an index which is somewhat broad. Does that speak to a remand, or how can we essentially import the FBI's answers to FOIA exemption to the state litigation?
Yes, Your Honor. So I'm sorry, my connection cut out just a little bit during your question there, but I think I got the gist of it. So tell me if I'm off base with my answer. So I think there are two justifications for essentially reading PRL Exemption F and FOIA Exemption 7A as essentially categorical matches. The first is that state courts should defer to the expertise of the federal agency that owns the federal records, engaging the likely downstream effects of public disclosure of its own records. And the second is that in the event that the courts of the Commonwealth contravene the federal agency's express determination against public disclosure, in this case, the resulting harm to the FBI's interests and the steps that the Bureau will be forced to take to safeguard those interests in the future are almost certain to prejudice the prospect of effective federal, state, and local law enforcement cooperation in a manner that is contrary to the public interest. I don't think either of those justifications requires a granular re-examination by this court of the FBI's FOIA analysis or a more granular explanation about why disclosure of these FBI determined non-FOIAble documents would be harmful to law enforcement interests under Exemption F.
Thank you. And I think Justice Kafka probably has a question on supremacy clause, so she probably turn to that. Justice Kafka?
The way you answered that question, Mr. Handel, which is they should defer, but you're not saying, are you suggesting that if they come to opposite conclusions, it's not a preemption problem? It's not a supremacy clause problem? Because you're softening this a little, and I'm just trying to understand why you're doing it that way. If we come to the opposite conclusion, interpreting a parallel investigatory language, is that not a federal conflict that's going to be a supremacy clause problem?
Your Honor, I absolutely do think that would pose a supremacy clause problem. I wanted to open with the idea that these statutory schemes can and should be harmonized, because I think that that's in the interest of the federal government and the state government to operate their law enforcement and public disclosure regimes in harmony where possible. But if this court determines that there's no way to harmonize the demands of state law with the FBI's application of federal law in this case, then you are absolutely correct. The latter must prevail. And that's because release under the PRL would directly conflict with the federal government's determination that public disclosure of these sensitive federal law enforcement records will inhibit statutorily recognized federal interests. Ms. Rahim, in both her briefs and in my friend's presentation today, has not disputed that the FBI documents are federal records and federal property. In FOIA, Congress authorized federal agencies to withhold federal records from public disclosure if they meet certain criteria. The FBI has determined that these records satisfy those criteria because public disclosure could reasonably be expected to interfere with enforcement proceedings. So in this context,
Randall, just to help us a little bit. So can you address the three cases that we've been talking about then? Is the Missouri case just wrong? Is the Washington case distinguishable? And is Napper correct? Or just, can you take us through a brief journey through those three cases, if you could?
Sure. So at a high level, I would say the problem with all of the cases that were cited by our friends on the other side is that none of them exhibit the kind of two benchmarks of federal control that we have here. First, on the front end, the FBI's reservation of rights through its letter transmitting these documents, which put the district attorney on notice that the FBI was retaining its control over these records. It was not relinquishing any sort of federal proprietary rights. And then on the back end, the FBI's determination, specifically with respect to these documents in the context of federal FOIA, that public disclosure would be harmful to federal interests. I don't think any of the other cases that have been cited have both of those factors. And I would specifically differentiate the Missouri case. So I think this was Harper versus State Highway Patrol. There's a couple of things that make that particularly in a posit here. So first, the intermediate appellate court in that case considered a narrative report created by the State Highway Patrol that attached a copy of an FBI report. And the court found that the records at issue are not agency records for the purposes of FOIA. That's a direct quote from the decision. So already this is a very different case because no one here contests that the FBI documents at issue in this litigation are federal agency records subject to FOIA. Second, the Harper case contains no discussion of whether the FBI made any express reservation of its rights when it provided a copy of its report to the state agency, nor did the claimant in that case, as far as I'm aware, avail herself of the federal FOIA process, receive a reasoned federal determination against disclosure, and then come to state court to make an end run around that determination. So unlike here, in that case, there was no clear conflict between the federal government and the state with respect to public disclosure. And I believe that the same holds true with the Washington case. I don't recall what the third case was that we were discussing.
Justice Gaziano wants to keep you in certain time constraints, given how many other cases we still have to go. So I will not ask for all three.
Sure.
Any further questions of Mr. Handel? Thank you, counsel.
Thank you very much.
Your honors.
Thank you.